So what is, in fact, a conservatorship? Let's start with some key terms so we understand what we're dealing with. This will make the presentation easier to understand, and in the future, when you see these terms, they'll pop right out. You'll understand what they mean. They can be confusing. Some of them sound very similar. Conservatee is our individual who requires the protection and assistance. That is our incapacitated individual. In this case, it's our individual with the developmental disability, or otherwise known as DD. Our conservator is the person or entity appointed to manage. In some cases, an entity can manage, such as a government organization. But the conservator, in essence, is a family member or other loved one or professional fiduciary who, after being appointed by the court, takes control over the conservatee's life, whether it be personal, medical decisions, or it be financial decisions. The petitioner is the individual bringing the papers to court. They're filing that petition. Okay, so they are not necessarily the conservator. They can be, but they are an interested party. In this case, it's usually a parent who is also petitioning to become the proposed conservator. Okay, but that's their role is petitioner. They are in charge of bringing that case, and they are going to be present in court as well. The regional center, for those of you who are in this process, the regional center is an excellent resource. You know who the regional center is. It's a private nonprofit agency that provides services and support to individuals with developmental disabilities. In San Diego, we call it the San Diego Regional Center, but every county essentially has their own regional center. And regional center is a crucial component of the conservatorship process, and we'll see how that plays out. Orders and letters, technical legal terms for the paperwork that a conservator is given when a case is granted. The order signed by the judge grants the petition, but the letters, as they're called, actually give that authority. And without letters, the order is essentially useless. In fact, the order states appointment is not effective until letters have issued. And so having letters issued properly is essential to allowing the conservator to immediately start protecting that conservatee. So what are we talking about when we discuss conservatorships? In probate, we have two general broad categories of conservatorship. Essentially, it's a court proceeding where the judge appoints a family member or friend or a professional, depending on the circumstances, who they call the conservator, to manage the personal care or the finances of an adult that the court finds is unable to do so because they lack capacity. In this scenario, for a limited conservatorship, that would be someone who has a qualifying developmental disability, and the court determines that they are unable to manage their own care. And we'll see what that looks like in a moment. We have a general and a limited. A general conservatorship is what we call full conservatorship. It's broad. It gives conservator more control over the conservatee. It allows for the most control in probate. And typically, these are reserved for individuals that are elderly with dementia or have some other traumatic brain injury, and they require complete control. Many times they lose their autonomy completely. They lose their brain functioning completely. And in most instances, we don't see that with a limited conservatorship. We do see it, but not as prevalent with the generals. And so the limited conservatorship was created for the purpose to carve out a level of independence for these individuals. So if you have a qualifying developmental disability and you are an adult, if you cannot care for yourself, the court's going to consider can we tailor the powers in the probate conservatorship to meet only the needs that you require? Instead of giving broad powers, we're going to tailor that to make sure that this individual's independence, as best as possible, is preserved. Okay, so the baseline rule for a limited conservatorship is the conservatee keeps all the rights except those that are expressly limited in the court's order. In contrast, in a full general conservatorship with the broad powers, the conservatee loses almost all rights, with a few exceptions. And so the limited conservatorship was created for the purpose of ensuring that the limited conservatee continues as independently as possible. Sometimes that's not possible at all, and we grant broad powers, and sometimes it is possible. And we're going to see what that looks like. So in a limited conservatorship, we have key powers. There's 7 powers under the probate code. And how we determine which powers are granted to this individual, to the conservator, which rights are essentially taken away from that conservatee. It's a multi-level situation. Okay, there's multi-decision makers here. We have the regional center who gives input. We have the attorneys, and we have the judge. And in some instances, we have a court investigator, and we'll discuss that in a moment as well. But the 7 powers are as follows. We have residential decisions. Okay, so that's the ability of the conservator to establish the residence of this limited conservatee. So if it's determined that this individual does not have the ability to understand how to provide for their own shelter, okay, then the conservator can be given that right, and the conservatee can be limited in that right. And so that caretaker comes in and is able to find housing, secure housing in the place of that disabled person and make sure they're safe. Our second power is confidential records. It gives the conservator access to any confidential papers that a third party would otherwise not be entitled to of an adult. That includes HIPAA medical records, that when your child is 18, you are no longer entitled to their HIPAA, under HIPAA, to their medical records. And so you're not entitled to review legal documents for them without their express consent. Okay, examples of what confidential records might look like. If it's determined that this individual can't understand these records of their own, then the conservator can be given this power, and they can do it on the conservatee's behalf. Our third power under this limited conservatorship is marriage, the consent or the withhold of consent of marriage of the limited conservatee. Okay, that also includes registered domestic partnerships. And what that means is, if it's again determined that this individual does not understand the concept of marriage, or is vulnerable to fraud, someone may fraudulently try to marry them for some financial gain, then the conservator can be given the authority to stop a wedding or withhold the consent, or even allow this person to marry someone. Okay, they have that power. And our fourth is the right to contract. Okay, so once you're determined to be incapacitated as an individual, your mental capacity is, if it's adjudicated by a judge that you have no mental capacity to enter into a contract, then one, you can be subject to fraud and undue influence, right? You can be taken advantage of, signing something you don't understand. And that happens a lot, which is why conservatorships can help individuals who are vulnerable. Well, in this instance, if again it's determined that the individual cannot understand contracts, they can't understand reading documents, then their caretaker will be given the ability to do it for them. Okay, so they can sign contracts on behalf of this person. Our fifth power is medical consent. Okay, and this is a huge one. Medical consent is the most sought after power under limited conservatorship. It's usually the most dire and the most necessary power. And that's the power uh, of the conservatee to give or withhold their own consent. And it's a high bar to convince the court that someone does not have the ability to consent to their own medical care. Okay, and we have the three levels, the regional center, the attorneys, and the judges who are reviewing this to ensure that it is appropriate. There's an extra level with this fifth power, and that is a physician, ideally a physician that's very known to this individual with a disability or in their regular care. They have to complete a very specific medical document that sets forth their opinion on the capacity of this individual to consent to their own medical decisions. That is, seeing a doctor, talking to a doctor, consent to surgeries, consent to medications, filling prescriptions, okay? Anything regarding medical consent that we take for granted as able-bodied individuals, okay? And as a parent, you naturally have done this for your child until you're told you cannot. And what happens is when the child who's disabled reaches 18, many times insurance companies and doctors will tell you, I'm sorry, I know you're their parent. They're 18. I can't allow you to take them to the doctor, review their medical history, consent to their medications, fill their prescriptions, sometimes even be in the room with them in a medical appointment. Okay. And so when you've raised a child that has these limitations, and then one day you're told, sorry, you can't do it. He or she just turned 18. It's hard. It's a shock. And so this power is often sought, and it's often needed immediately because these individuals naturally have ongoing medical needs that can't wait. And so medical consent is probably the most common power to be included in a final order. Some of these others, you would see that they may have the ability to understand, uh, their residents' decisions, but not medical decisions. And so we can tailor that and only apply the ones that seem the most appropriate. And so once that physician fills out that paperwork, it goes back to the court. It's reviewed by attorneys, it's reviewed by the regional center, and it's reviewed by the judge. And if there's any discrepancies, then the proceeding would be continued and they're back to the doctor to fix those discrepancies. If there's any question as to the doctor's opinion, or if the doctor's opinion is not quite as strong as the parent might like it to be. The parent might understand that, well, my child has these limitations, but the doctor's point of view might be, well, they don't quite arrive to the level where I'm going to be comfortable allowing you, even though you're a parent, now you're a conservator, it's a different role. The doctor might not feel comfortable allowing this individual to consent for medical care. And and so it can get complicated when that happens, but that's why the court process already has fail safes with the levels of supervision, regional center attorneys, judges, and doctors. So moving on to our sixth power is our social sexual contacts. Okay, and this one is probably the power uh, that is limited the most because many individuals they are capable of understanding their own social circle. Now, sometimes with the sexual contacts, it can be dangerous and tricky because an individual with limited capacity might get themselves in a bad situation. And so, again, it's going to be the regional center and the attorneys and the judge evaluating whether it's appropriate. But If a conservator is given the right to limit the social contacts of this individual, then as a conservator, you have the right to say you cannot be friends with this person, you cannot have a close relationship with this person, and they can prevent any relationships in order to safeguard. The point is to safeguard this individual, right? And our final seventh power is education. Okay, so decisions concerning the education of a limited conservatee. Another power that is often omitted because this individual has an ability to understand their own educational choices, which are often limited for developmental disabled individuals, but there are many wonderful programs available, and a conservator can do wonderful things, having the ability to decide what types of programs and education that their conservatee can attend. And so um, it is a necessary power for ensuring that the disabled person is not left behind. They're constantly having stimulus and interaction, and the educational options, educational power is essential for that. And so the powers are limited to what is essential, as I kept saying, right? And so the idea of a limited conservatorship is we are promoting independence. So you may be awarded the seven powers as a conservator. You may not. Okay. You may even have an estate power, which is rare in limited conservatorships. And we're not going to get into too much detail about estate powers in this presentation. And if you have a question on specific estate powers, you can contact our office and we'd be happy to discuss that with you. But a component of a conservatorship can be management of finances, which is more typical in the broad conservatorship versus the limited conservatorships. So on the topic of the regional center, let's define what their role actually is. So San Diego, we have the San Diego Regional Center. Okay. And their job is assessment, reporting, and support. Okay. In the court process, the probate code actually demands that they're involved. It's not an option. And so they have to provide an assessment of this individual and a letter to the court that um, either supports or denies the powers requested by the petition. And so once a petition is filed, they must receive a copy, and they assess those powers. They speak with family, and they speak with their client, the individual with the disability, and they make that assessment. Okay, and that's simply for the court process. And they're either going to agree with the powers you request in your petition, or they may disagree, and they may say, no, we actually think that this individual has autonomy in this area. We've been working with them, and we're going to recommend that power not be granted. Okay, so the judges heavily rely on the regional center report in this process, and they cannot adjudicate a conservatorship without a regional center report. It is mandatory. Probate Code 1827.5. When a court process is not underway, the regional center is still extraordinarily crucial because they provide support to the family and to the disabled individual. And they're helping access services, they're providing ongoing support, okay? And beyond conservatorship appointment or before conservatorship appointment, when these individuals are children, they are playing a very important role in providing services, matching them with educational choices, and assisting families who are overwhelmed in understanding how to care for an individual with a particular disability. So regional center is an important part of the process. So I mentioned attorneys, I mentioned conservators, and there's a few individuals in the court process that you should understand when when filing a petition for conservatorship. And so we have multiple levels of attorneys here. The first is the attorney for the petitioner. Again, the petitioner is the individual who files the petition stating that in most instances, their child, who is now 18 or older, needs the help. They need a conservator. So the attorney for the petitioner is going to represent the petitioner, often the parents, okay, in navigating the court and securing that conservatorship. Now, oddly enough, the disabled person is actually deemed a counterparty, okay, to the petitioner. And so the moment you file that, if you're a parent, your child automatically becomes an opposing party, so to speak, in the proceeding. Okay. And so they have to be appointed their own legal counsel to secure their rights. Okay. Because we're talking about taking away liberties of this person that we all have, that we take for granted. You're taking them away and giving them to someone else. And even if it's a parent, the courts treat it as if it's not a parent. The parental relationship is really caged for a moment, and we look at that person as a third party who is attempting to take over this disabled individual's rights. Okay, so the law mandates in California that we appoint an attorney. The court in every county in California has a list of attorneys whom have volunteered to work at a much lower rate, sometimes even free, to represent these disabled individuals during the process of conservatorship. Okay, and so as a matter of course, the moment you file, this disabled person is going to have an attorney given to them the moment you file. Okay. And so we call them court-appointed attorney in San Diego. Some counties, they use the public defender's office. Some counties, they call them something completely different. But in San Diego County, we're calling it a CAA, court-appointed attorney. And their job is to meet with this proposed conservatee, the disabled individual, as best as they can, and discuss the proceeding with them. Sometimes they can have a wonderful conversation because this individual has the ability to do so, and sometimes it's impossible. But regardless of the level of disability and what the diagnosis is, the attorney must make contact. They must discuss and give certain rights to this individual. Now, I myself am on this court-appointed panel in San Diego, so I have firsthand understanding of how this works. And so you have to take a different role. In some roles, you represent the petitioner, okay? And in some roles, in some cases, you represent the disabled person. And so your focus changes, okay? When you're representing the disabled person, you ensure their rights are protected, right? Is this petition warranted? Can this disabled person have a conversation with me and say, I don't want this? If they have the ability to do that, then we have to assess that immediately, and we have to report that to the court. And the court-appointed attorney will do that very thing. They will file a report and state their recommendations. Now, it seems counterintuitive because most of us think, well, I mean, this individual is disabled. They might not understand what they're saying no to. And, many times that could be the case. But there are times when it's not the case. If you just look at Britney Spears and what happened to Britney Spears, you might have a different opinion depending on which story you're reading about what happened to Britney Spears and her court-appointed attorney. And I have an excellent blog post about that on our website that you can read about Britney Spears' case. But in fact, it was the Britney Spears case that made the CAA requirement mandatory in California. Whereas before it was a little more nuanced, but now it's mandatory at any case filed for conservatorship. And Britney Spears' case is to thank for that. And so we're advocating for the rights of that person. If they're telling me, I don't want this, regardless of my opinion of what their mental capacity is, while I'm gonna weave some of that into the report, I'm going to have to represent my client's interest. My client told me I don't want this. And so I have to say we object. Okay. And the parents might get frustrated and say, well, that doesn't make any sense. They don't know what they're objecting to. And that's why we have a multi-level process. We have the regional center who might support it. We have, we may have a court investigator, which I'll discuss in a moment. We have the judge looking at it. We have the physician. And so if the disabled individual says, I don't want it, but all the other parties are determining that it's necessary, then the likelihood of success is good. You may have to have a trial for it or an evidentiary hearing, as we might call it, a mini trial, but your chances of success are probably good unless the individual truly does have capacity and a conservatorship is inappropriate, then it will be denied. Okay. So let's move on to the conservator. So imagine you are the parent of this child, they're an adult, and you have a successful petition granted, and now suddenly you're not a parent anymore in the eyes of the court. Now you're a conservator. Okay. You're responsible as a fiduciary in most instances for the well-being of this conservatee, this disabled person. Okay. They're held to a higher standard of care as a parent, in fact. Okay. And so I've heard judges myself say, you're not a parent anymore in this court. You're a conservator. And so you're going to act like one. And so that might be confusing for some parents because they have to understand that they have to treat this individual as if it wasn't a child, but as if they're a caretaker looking after a third party with the utmost care standard. Okay. And so once you become a conservator, then you have to take a class. You have to sign off that you took this class. It educates you on what to do as a conservator. You're given a long list of duties and to understand what is my duty as a conservator, which could be quite different as your duty of a parent as a parent. Okay. And you're going to be this conservator until the conservatorship is terminated, and the conservatorship can be terminated a few ways. Okay. It is by court order if the court determines it's no longer necessary. And in a limited conservatorship, death of either party. If the conservative person dies, the conservatorship is terminated. If the conservator dies and there's no other conservator acting in conjunction with that, a co-conservator, then in fact the conservatorship terminates by law and a new petition would have to be filed. Okay, and so these things can get nuanced and a little bit complicated. How many conservators should we appoint to to um, to help in that situation if you're worried that this individual might be left suddenly without a conservator if one conservator passes away? And so that's something that we have to understand when we file, and it's something that we often battle by having two parents at the same time or a parent and an older sibling, which is often the case. And that older sibling understands they are a current conservator, but once mom or dad is no longer there, they can really take over without any gap in care for their sibling. Our next individual in the court process is a probate court investigator. Okay, so the court actually employs investigators whose job it is to conduct interviews in conservatorship cases. Okay, so they report on the conservatee's well-being, the conservator's actions, any problems they discover with the case, and they file a report with the judge. The conservator will receive a copy. Now, the process of how the court investigator is appointed is highly dependent on the county's budget, unfortunately. And each county in California is going to have a different allocation of the budget in the courts. And because of that, they have the ability to either provide for every investigation that the probate code mandates, or they can tailor it like they do here in San Diego to only what's essential. And so in a limited conservatorship, you may not see this investigator until the conservatorship is established. In other counties, you'll see this investigator from the beginning, and they're going to conduct an investigation when you file. And I will explain a little bit more about that in this next navigating the process. Okay, so these, in my opinion, these are the 6 most important items in the process that you should understand, and they're the most confused. And a lot of these will, if not done correctly, your case will be held up for months. Okay, so the first thing is you file your petition, right? Someone is going to file the petition in the probate court, okay, with supporting documents. The conservatorship paperwork is quite lengthy. It's a very a large packet of information that has to be filed. Okay, so it's a bit daunting. Okay, so you file that. Now you have a case number, you have a judge, you have a date, and have a time. And most likely it's months into the future. The next crucial process is legal notice. Okay, and so formal notice has to be given per the law. Okay, there's very specific probate code that says how notice is to be given in conjunction with Code of Civil Procedure in California. Okay, so the conservatee, the disabled person, has to be personally served with the documents. It doesn't matter if they're in a coma. It doesn't matter if they are completely of capacity. It doesn't matter if they can read, if they're blind. It doesn't matter what their ailment is at all. They must be personally delivered with the documents, because capacity is always presumed in the law unless it is taken away. And so filing the petition doesn't mean that we've automatically lost capacity for this person, even if it's clear that they're in a coma, for example. Capacity is presumed. And so we must provide personal service to that person. And sometimes it's as simple as laying the documents next to them at the hospital. Okay, many cases I've done myself, we've had to do that. You lay the document next to them, and the doctors look at you like you're crazy, but that's how you have to do it, because that is proper notice. All interested family members have to be given a copy of this petition. They have to be contacted and given notice of the hearing, because they have a right to appear. They have a right to object. They can appear for moral support in the audience, or they can, if they disagree, they have a right to present their argument to the judge, and they have a right to file their own papers in opposition if they feel that either the powers are wrong or the individual requesting the powers shouldn't be the conservator. Okay, so that's when we can get into a litigated situation. Now, we have objections. Okay, but if you fail to give legal notice in the proper way, your case will not proceed. Okay, it doesn't matter if you fail it 10 times. You will go to court 10 times and you will not proceed. You will be continued, and eventually you'll be scolded, but you'll be admonished by the judge. So legal notice is very important. The third step during this process is we are contacted by the court-appointed attorney. Okay, we meaning the family. And if I'm the petitioning attorney, they're going to contact my office and ask for permission to contact my client, the parent, and say, I'd like to contact the parent so I can schedule a meeting with the child, with their child. It's not a child. They have to be 18, right? The disabled person. And so they make contact. So if you file this and you're a parent, you will receive a call from this court-appointed attorney. They will say, I have been appointed by the court to represent your child in this matter. I need to meet with them. And they have to do that. They have to meet with them privately. Okay. Um, if the disabled individuals has ability to consent to having a parent with them in the meeting, they can. But the law prescribes that the CAA must conduct this in private for fear that there is some kind of undue influence, right? We don't want coaching. We don't want this individual to be coached. And that's especially important when we are in the general conservatorships and we have dementia situations and money is involved. We see a lot of coaching. Okay, so but in limiteds, it's not as prevalent. These are 99% of the time very necessary, and it's a parent just trying to do the best for their child. Okay, so the CA is going to discuss the case with the conservatee as best as possible. Okay, and they're going to write a report to the court and make a recommendation on how the judge should rule. And in court, they will make their appearance and they will state that on the record. Our fourth item in the process is court's staff review. So there's multiple levels of staff in the court that are going to review the papers, and they're very important. Okay. So first is our probate examiner. The probate examiner is a paralegal, and they are employed by the court. And what they do is they review all the pleadings that you file to make sure they're legally compliant. Did you provide the notice and the proof? Are you requesting the proper powers? Did you check all the right boxes? Did you file all the right documents? Okay, all those things are going to be flagged by the probate examiner. The judge will receive those notes. You will receive a copy of the notes, and you'll have an opportunity to address that with the examiner. Okay. And we have our court investigator who contacts the parties and submits their report. Now, why do I have an asterisk? Because in San Diego, as I was saying, we don't do initial, okay, we don't do investigations when you file a limited conservatorship. Okay, it's a budget issue. It's always been, and I suspect it always will be. Other counties, they do go out on limited conservatorships and in the beginning of the process. But in San Diego, you will not hear from a court investigator in a limited conservatorship until a year after, okay, to conduct what's called a review. All right. And so a little bit different in San Diego than some counties, but you will have a knock on your door someday that says, "Hi, I'm with the court. I'm here to investigate your conservatorship, make sure that everything is still going well." Our fifth step in the court process is our court hearing. Okay. Um, you can do that in person or you can do that on MS Teams. Okay. MS Teams is virtual. It's become quite popular, and the courtroom is sometimes empty, and everyone's appearing online. So that makes it a lot easier because you don't have to transport the conservatee to court like in the old days. Okay. And in most cases, all parties and attorneys are present at the hearing, including the disabled individual. However, medical exceptions can apply where they can be excused, but that has to be confirmed by a physician as well. You cannot exclude them because you say they can't attend. The physician and their attorney has to confirm, in fact, it's not a good idea for them to attend because they have their disability wouldn't allow it. The judge is going to give advisements at the beginning of the calendar. They're going to address they're going to state certain rights to the conservatees as required by law. And if you have no issues and everyone's in agreement, your petition is granted. Okay, then you're moving on to step 6. If there's issues or an objection, perhaps you had a defect on your probate notes from the examiner, you're not going to have a granted petition. You're not moving on to step 6. You're going to have a continuance, and you're going to go back to step 5 after you've corrected the problems. Okay, so correct those problems as soon as possible. And in our step 6, we have our post-hearing documents. Okay, the judge signs an order for appointment. Letters are issued to a conservator. It gives them the power to act. Conservators have to take an online orientation, and now they have the ability to make those decisions for that individual. Okay, they have documents to submit. The submitting paperwork doesn't stop once the hearing is over. There are more things to submit. Okay, so let's go through some pitfalls on how to avoid them. Okay, so one, you're seeking powers that are too broad. Okay, or you're selecting the wrong powers. Okay, so if the regional center doesn't agree, then you may not get your petition granted. Okay, if you're selecting the wrong powers, okay, same concept. If the regional center doesn't agree, then you may have to start over. Okay. Ignoring the alternatives. Okay, so we have to discuss alternatives to conservatorship. Conservatorship is restrictive. If there is an alternative, then we may try to explore that if it's possible. However, many times conservatorship is the only option. We'll discuss what the alternatives look like momentarily. Conservatee must also be 18. This is an adult proceeding. A minor is in California, that's a guardianship. It's a different proceeding in entirety. Conservatorship concerns adults. Okay, and item 4, you're failing to provide adequate notice. I mentioned that prior. Notice is key. Use a process server, a professional to handle the personal service so you don't mess it up. Make sure someone else is providing notice. You are not to mail documents yourself if you're a party. You are not to serve documents yourself if you're a party. Okay, that's true for just about any case type under the law. And item 5, not addressing the court's defects. Okay, so that court examiner, that paralegal is going to produce a list of defects you about a month before, okay? And you have an ability to contact that person and discuss what they are, or your attorney will look at that and fix them if there's anything. Okay, and if you don't do it in time and you're late on filing documents or you fail to, you're not moving on to that step 6. Your hearing is continued and you're gonna be pushed out into the future. And finally, our 6th most common pitfall is forgetting your orders and letters. Okay, you forget to submit them. Now, I've seen many times where the conservatorship hearing took place 2 years ago, but no one submitted orders and no one submitted letters. Essentially, there is no authority, zero, without a signed order from a judge and the letters stamped by the clerk. And so you spent all that time and all that energy seeking conservatorship. It was granted, but you never had order signed by the judge because you forgot to submit it, and you never had your letters stamped issued. And so now you actually don't have any authority whatsoever. And when you do submit those, you watch out for typos. Rejections are common. The clerk can reject it if the wrong box is checked, and now you're going back and forth, sometimes for months, trying to get this paperwork stamped and filed. Okay, we are nearing the end here. What to expect post-appointment? Okay, so more documents filed. We have something called Notice of Conservatee's Rights and a confidential conservatorship care plan. It's a 2-part document. Those have to be filed within 120 days of appointment. Okay, and if you don't file them, you'll receive a notice, failure to perform. And if you go 60 days past the deadline, you will be called to court and you could be sanctioned for not doing that. Okay, so it's important that after appointment, you don't just stop. There's more things to do. 2 years, the first year, and then 2 years thereafter, okay, after those letters are granted, you will receive a call from the court investigator who's going to review the case. And they are going to meet with the disabled person, the conservatee, in private. They're going to discuss the conservatorship. They're going to give them their advisement of rights and say, you're under a conservatorship. You have the right to object to a conservatorship. You have the right to seek a court hearing on your conservatorship. They're going to do that every 2 years. They're going to make sure that your actions as conservator are just and proper. Okay? And they're going to write a report to the court to that effect, whatever they determine. And you will, of course, receive a copy if you are the conservator. And you actually have an ability to respond to that if you wanted to. As a conservator, now it's your time to present your letters and manage the care. Remember, you're not a parent anymore. in the eyes of the court, you're a conservator. You're going to be asked for the proof by third parties, the doctor's office, insurance companies. They're going to want to see those letters. You can even record them with the county assessor's office if you're dealing with property. Okay. And so your role does change from parent to decision maker under court supervision. You're held to a high standard. Okay, let's quickly go through the alternatives of conservatorship. Okay, power of attorney. Okay, do we need a conservatorship or can we accomplish this through power of attorney? So, a power of attorney authorizes an agent to handle money, benefits, contracts, banking, and taxes. Okay, you can make that immediate or springing. It only comes into effect at a certain point. That's called springing. What is it good for? Paying bills, managing accounts, dealing with landlords, utilities, etc. But what are the limits? Okay, you need capacity in the first place to sign it. So your child turns 18, they've had a disability their whole life. Does their disability preclude them from signing a contract? It probably does. So it's an alternative, but it's very limited to those individuals who really do have capacity. Okay. Maybe autism spectrum. They can, they're very high functioning. They can sign a power of attorney without a problem. So we wouldn't seek conservatorship there. Okay. Advanced healthcare directive, similar. It's a power of attorney for medical decisions. It's the same concept, right? So it's good to manage medical decisions if that individual has the capacity in the first place to give you that power. Okay. So it doesn't always work. We have what's called supported decision making. And in 2023 to 2025, the courts have really been pushing this. And the idea is if this individual can be supported without court intervention, they want to see the attempts to do that first. Okay, they call that circle of support. Okay. You can maximize the autonomy of this person without having the court involved. But there are limits, of course. Okay. If you develop a decision-making agreement, you don't have legal authority to act for the person. Okay, so third-party acceptance is not necessary, right? So if you have your child who's now 20 and says, "I agree that my mom can take care of me," that's wonderful. But the doctor doesn't have to accept it. So it's great and it's idealistic, but it doesn't always work. And so conservatorship ends up still becoming necessary. There is one other alternative, and we call that a court order for specific medical decisions. Okay, it's not a conservatorship. It's targeted for a single medical issue, a surgery, for example. So, but without the need for appointing a conservator. So it's good for a one-off decision where this person lacks capacity. You need a decision just to do a surgery. You can ask the court to give you that, but that's it. Once the surgery is done, you have no other power. Okay, so it's very narrow. It's not continuous. You have to return to court for the next procedure. It's not ideal, but it is available. Okay, so concluding remarks. How much does all this cost? It's difficult to say. So each client has different needs, and we have to assess that individually. So we can't give a blanket cost, but you can contact us. We can discuss your individual situation and what we would project a cost would be. And there are instances where if the disabled individual is on medical benefits from the state, Medi-Cal, SSI, SSA, you may be able to ask the court to waive your filing fees. Okay. And the court appointed attorney would be paid by the county rather than out of your pocket. And so that's an option to save some money in this process. How long does it take? The court does have a backlog. It could be pretty significant. Filing a petition in April may give you a hearing date in October, maybe December. Okay, now there are situations where we can speed that up under emergency type situations on a temporary basis, and those can be heard within 3 or 4 weeks, but we have to show a dire need for that. that would be something that you would have to discuss as an individual basis. But this is not a short process. This is a long process. Okay, the court process typically is never short. Okay, well, I want to thank you for joining. You can contact our office here